Breaking news, millions of naturalized Americans are waking up this morning genuinely terrified that the country they built their lives in could take back the one thing they earned, their citizenship. Group chats are exploding. Social media is flooded with warnings. People are saying the government has a new power to cancel your citizenship overnight. No court, no warning, no appeal. And here is what makes this even more alarming. Some of what you are hearing is not entirely wrong. Something has changed. Federal agencies are actively digging through old files. Digital systems are cross-referencing applications filed 20, even 30 years ago. Real people are being flagged. But here is the part nobody is telling you clearly. There is a massive legal difference between being flagged and losing your citizenship. And if you do not understand that difference right now, fear will make every decision for you. Stay with me, because by the end of this video, you will know exactly what is happening, who is truly at risk, what your rights are, and what you should do today to protect yourself. I am your host on Global Updates 24, the channel that cuts through the noise and gives you the facts that actually matter. If this is your first time here, hit subscribe right now and turn on notifications, because this topic is moving fast and we will keep you ahead of it. And if someone you know needs to hear this, share this video with them. It could genuinely make a difference. Let us get into it. To understand what is actually happening in 2026, you have to separate two things that people keep confusing: the law itself and how aggressively that law is being enforced, because those are two very different conversations. Since returning to office in January 2025, President Trump has made immigration enforcement a defining priority of his administration. Executive directives have called for stricter compliance reviews, expanded fraud detection, and deep audits of past immigration records going back decades. By early 2026, federal agencies began allocating serious personnel and cutting-edge digital resources toward reviewing naturalization histories, specifically hunting for cases where there were inconsistencies, criminal omissions, or suspected misrepresentations during the original application process. That shift has caused enormous anxiety across immigrant communities, and honestly, the anxiety is understandable. But here is the single most important legal fact you need to anchor yourself to right now. The law governing citizenship has not fundamentally changed. There is no new statute that makes it easier for the government to cancel your citizenship. There is no executive order that lets agencies revoke it with the click of a button. United States citizenship is protected under the Constitution, and it cannot be taken away casually, administratively, or through a simple internal agency decision. What has changed is the intensity of the review and the technology being used to conduct it. Federal agencies are now deploying advanced digital cross-check systems that simply did not exist in this form a decade ago. Paper archives have been digitized. Old naturalization applications are being compared in real time against criminal databases, travel records, asylum filings, visa histories, and foreign data sources. Information that once required months of manual digging can now be flagged in seconds. A name variation across two documents, flagged. A criminal charge that predates naturalization but does not appear in the application, detected almost instantly. That technological evolution is one of the biggest reasons older cases are resurfacing right now. But here is the distinction that changes everything. A digital flag is not a court judgment. Being reviewed is not the same as losing anything. And for the millions of naturalized citizens who were honest, met all the requirements, and completed their process lawfully, increased enforcement intensity does not automatically create danger. Now, let us talk about denaturalization, because this is the legal process at the center of everything, and most people have no idea how it actually works. Denaturalization is not new. It has existed for decades under federal immigration law. It is the process by which the government can seek to revoke citizenship, but only under very specific circumstances. And most critically, it requires a formal lawsuit filed in federal court. That means evidence must be presented before a judge. The government carries the full burden of proof. The standard required is clear and convincing evidence. That is a high bar. And the individual has every right to defend themselves with legal counsel. There is no secret administrative shortcut. There is no surprise cancellation letter that erases your status overnight. Without a federal court case, there is no denaturalization. Full stop. That structure has not changed in 2026. So who is actually being scrutinized? Because this is where the online rumors go completely off the rails. The focus of federal enforcement right now is not on entire nationalities. It is not on everyone who immigrated during a specific decade. It is not on people who speak a different language at home or travel back to visit family. What investigators are zeroing in on is something far more specific and far more technical: whether citizenship was lawfully obtained at the time it was granted. That single distinction changes the entire conversation. Denaturalization does not center on what you did after becoming a citizen. It centers on whether there was fraud, concealment, or material misrepresentation during the immigration or naturalization process itself. One major category under scrutiny involves individuals who allegedly failed to disclose serious criminal history that existed before they naturalized, specifically offenses that would have blocked approval if they had been disclosed. We are not talking about parking tickets. We are not talking about minor traffic violations from 30 years ago. We are talking about undisclosed arrests, convictions, or criminal conduct that legally would have disqualified someone at the time of application. Another category involves identity inconsistencies, situations where different names, dates of birth, or biographical details appear across multiple filings. Sometimes these are innocent clerical errors. Sometimes they raise deeper questions. The intent behind them becomes central in any court proceeding. Marriage-based green card cases are also under review in certain instances. If permanent residency was obtained through a fraudulent marriage and that residency later formed the foundation for citizenship, the entire chain of that process can be legally examined. And there is scrutiny of cases involving undisclosed affiliations with organizations that could have made someone inadmissible during the original process. None of these categories were invented in 2026. They have always existed in immigration law. What is new is the digital firepower being used to detect them. Here is where fear floods in and replaces facts. Not every mistake qualifies as fraud. The law requires that any misrepresentation be what lawyers call material. That word carries enormous weight. Material means significant enough that if the truth had been known, citizenship would not have been granted. A typo on a form is not material. A forgotten short trip abroad is not material. A minor offense that had zero impact on eligibility is not material. The government must demonstrate that the alleged concealment actually mattered to the outcome, and that is a genuinely high legal bar to clear. Now, let us deal with the rumors directly, because some of what is circulating online right now is dangerously misleading. One of the biggest claims is that naturalized citizens are being mass deported. That is not accurate. Even with dramatically intensified enforcement, denaturalization cases represent a very small fraction of the tens of millions of naturalized citizens living in the United States. These are individualized legal actions based on specific allegations tied to a specific person's original application, not sweeping operations targeting entire immigrant communities. The word mass generates clicks. It does not reflect legal reality. Another claim spreading across social media suggests that speaking your native language, traveling back to your country of origin, or maintaining dual citizenship puts you at risk. That is false. The United States does not require cultural abandonment as a condition of citizenship. You can speak your language, you can visit family, you can maintain ties to your heritage. In most cases, dual citizenship is fully permitted. None of those things automatically trigger denaturalization. And here is a critical legal distinction that most people do not know. Once you are a naturalized citizen, crimes committed after naturalization generally do not make you deportable. Deportation is a consequence that applies to non-citizens. A citizen cannot be deported unless citizenship is first formally revoked through a court process. The timing matters enormously. Criminal conduct only becomes relevant to denaturalization if it existed before naturalization and was deliberately concealed in a way that affected eligibility. Now, if you are ever contacted, whether through a letter requesting information or even an unexpected visit from federal agents, you are not required to answer detailed questions without legal counsel present. You can calmly, clearly state that you wish to consult an attorney before responding. That is not guilt. That is the Constitution working exactly as it was designed to work. You have the right to respond to any federal court action. You have the right to review the evidence. You have the right to challenge it and present your own defense. And if a ruling ever went against you, the appeals process exists precisely to review whether the law was properly applied and whether your constitutional protections were respected. The judicial system has safeguards against abuse. The government cannot endlessly retry the same claim without new evidence. So where does this leave you right now? Not in panic, in preparation. If you are a naturalized citizen who disclosed your history honestly, met all eligibility requirements, and completed your process lawfully, your citizenship remains one of the strongest legal protections in existence under United States law. But stronger enforcement does mean that preparation matters more today than it once did. Start by organizing your documents. Keep copies of your naturalization certificate, your green card records, and your original applications, including all supporting documents. Maintain both digital backups and physical copies stored securely. Documentation is your strongest ally if questions ever arise. If your immigration history included any complexity, prior overstays, name variations, past charges, or multiple filings under different circumstances, consider scheduling a confidential review with an experienced immigration attorney. Not because you are automatically at risk, but because clarity eliminates uncertainty. And if you ever receive any official correspondence referencing your naturalization, do not ignore it. Do not assume it is a mistake, and do not try to navigate it alone. Early legal guidance can prevent small issues from becoming serious ones. And for green card holders watching this, Permanent residents do not have the same constitutional shield that naturalized citizens hold. Status can be revoked more easily if serious violations occur. That makes compliance essential. File your taxes consistently. Maintain continuous residence. Apply for citizenship as soon as you are eligible. Citizenship is not just symbolic, it is structural protection. The system of checks and balances in this country remains active. Courts continue to impose standards. Due process still governs outcomes. Technology has evolved. Data systems are more powerful, and historical inconsistencies are easier to detect. That is real. But constitutional safeguards are real too. Fear spreads faster than facts, but facts are what protect you. That is why this channel exists. If this breakdown helped you replace confusion with clarity, please like this video right now. It tells us you want more content like this. Share it with anyone in your community who needs to hear the truth instead of the panic. And subscribe to Global Updates 24 so you never miss an update as these policies continue to evolve throughout 2026. We will be right here watching every development, breaking it down, and making sure you always know exactly where you stand. Stay informed, stay prepared, and we will see you in the next one.